Okay, hi, morning everyone. I've been asked to present to you this decision of Kaldor versus Lian, which is one of the latest cases in which deals with the issue of copying of a design. Just by way of background facts, I've included in your pack sort of a key document which shows the two designs that were in issue and the degree of similarity between them. So just looking at the facts, the issue here was that John Kaldor, some of you might know as a fabric designer, while the defendant to this matter was Lian, a company which makes and designs garments. And by way of brief facts, leading up to these two designs, Lian was briefed by Marks and Spencer's to effectively pitch fabrics to be used in one of Marks and Spencer's clothing collections. It was called Per Una. Some of you might remember that. It was it translates, I think, into for her, and it's from Italian to English. And for this purpose, John Kaldor had supplied, the claimants had supplied some fabrics to Lian, and the issue was that Lian, the designer at Lian, had seen apparently had seen this design, had considered it, and then the pitch was made to Marks and Spencer's. It was successful, but ultimately the John Kaldor fabric, which is the one in Annex 1 of the first picture you can see, was not used for the purposes of the Marks and Spencer's collection. But once this collection, this Per Una collection, came out, effectively all hell broke loose, because it transpired that one of the dresses in the Marks and Spencer's collection had a, well, as you can see, I think a pretty similar tribal print design. It's not exactly the same, but certainly on an objective level it looks quite similar. It's a bit like if you saw the Joseph bag. If you simply removed a few of those features, it would look roughly the same. And the question really for the judge was whether or not that was enough. So I'm just going to, there you have the two prints, and the question for the court, which looked at how to determine these sorts of cases, the question for the court was whether or not these similarities were enough in and of themselves to establish copying. And of course different opinions could be taken as to whether or not they are similar and how similar they are, but I think the general consensus in the fashion industry afterwards was that they were pretty much identical. So the question is, what's the law on this, which is quite interesting, and I've set out in summary fashion. Obviously it's a bit more complicated than that, but in summary fashion the law is contained, or at least the crux of the law is contained in section 16 of the Copyright Designs and Patents Act. And effectively, and this is just a summary, the claimant has to establish that the alleged infringing article was copied directly or indirectly from the copyright work, and that the act of copying was done in relation to the work as a whole or any substantial part of it. But effectively, what does that mean? And this was previously considered in the courts in a case called Stud Art International and Lomas Carpets Limited, which established that usually this is proven, or at least the copying, whether or not something was copied, is established effectively by way of inference. It's quite rare, I think, for someone to be able to go off and provide direct evidence of copying. Designers don't have, as the judge put it, spies at their side, so it's quite rare for someone to say, well, here you go, there's a document and it proves that this was copied, or usually it's proven by way of inferences, and those inferences are drawn from what are objective similarities. So you'd think that in a case like this there are quite a few objective similarities. If you look at those two designs, they are objectively, I think, quite similar. But the question was, for the judge in this case, in Kaldor versus Lian, is that right? Is it fair to say, well, simply on the basis of objective similarities we find that there's a copy? Perhaps that would be a little bit too simplistic. So the onus following Stoddart, the onus, as I've put on the slide, the onus really shifted to a defendant to an action to satisfactorily explain the similarity. But the difficulty that the judge had in Kaldor was that effectively that could lead to the conclusion that every time there are objective similarities and every time someone cannot say, well, can't prove they didn't copy the design, then effectively that would mean that the judges almost always find that there was infringing copying going on. So in this case, the judge went a little bit further and found that the defendant shouldn't really have what he described as a mountain to climb following, if there is an allegation of copying, that effectively some onus should shift to the claimant to try to demonstrate the copying is going on. And the judge acknowledged in this case that, of course, for the purposes of Section 16, any direct evidence of copying will be rare. Judge Hakon had acknowledged that copying is to be proven by way of inference, but he went a bit further and established what can be described, these are sort of my words, but they can be described as a sort of sliding scale. The crux of the matter being that the stronger the evidence of copying there is, the more compelling the evidence from a defendant must be. So the defendant to an action here, Leanne, had to effectively give quite compelling evidence as to what the defendant did in terms of the defendant's design being its own design. But that is not a mountain to climb. It can't be impossible to prove that. It's if the defendant's evidence, for example, is quite compelling and not open significantly to challenge, then of course the defendant may be able to point to the fact that the design was its own. And there are various aspects of the sliding scale. So, for example, whether the judge will look at issues such as, for example, whether or not the design itself is commonplace. So you might think that, for example, the Joseph bags you saw are sort of quite commonplace, or the McDonald's golden arches are sort of commonplace designs. And if it's commonplace, the judge will also look at the scale following Kaldor within the commonplace nature of the design. So they'll look at issues pertaining to that. I'm just trying to find the right wording. So the judge, for example, found that similarities which are shown to be commonplace give rise to little or no inference of copying. The nearer a similarity approaches to the strikingly original end of the spectrum, the greater weight it carries in supporting an inference of copying. So it's all kind of to do with these inferences on a sliding scale. You might think that it's a sort of common sense decision. So what are the principles emerging out of Kaldor? I've put them up here. In some ways, there is still a burden on the defendant to demonstrate what the defendant did. But there is now, I would suggest, a more rigorous burden on the claimant. I would say it's a more rigorous burden than that was established in prior case law, which effectively gave the claimant carte blanche in a situation, especially like the one pertaining to Kaldor, where the two designs were very similar. And in this case, the overall result was that the claimant's evidence of copying was not compelling enough to give Justice Hakon effectively reason to disbelieve what he found was coherent evidence given by the defendant's principal witness, who was the designer. So the designer had actually come up with effectively a coherent account of her own design. And that is what perhaps some people find shocking, the fact that she'd accepted in her evidence that she'd seen the design of John Kaldor and considered it and despite that, there wasn't sufficient evidence of actual, or indeed subconscious copying. It wasn't enough. There wasn't enough evidence of that. So perhaps by way of practicality, what lessons I would suggest could be drawn from this decision. Now, I would suggest it's important to maintain records, an audit trail, and I've put here importance of the initial design brief. The judge, if you read the judgment, had looked very carefully at the brief that was given to the designer by Marks and Spencers and how that corresponded with what the designer in her evidence suggested had received from John Kaldor. So an audit trail now is particularly important when there is any risk whatsoever of a design being copied, because otherwise you may end up in court and simply without enough evidence to discharge the slightly greater burden on the claimant following this decision. So just again, what's the significance of Kaldor versus Leanne? Well, I think primarily mere objective similarities are not sufficient. I think it can be suggested that they used to be sufficient. So even if two designs are considered and there is an objective similarity or objective similarities, that's not sufficient. I would suggest that there is a sliding scale now in respect of proving an allegation of copying. It really is a matter of ultimately common sense, looking at the degree of copying or the degree of similarity there is, and obviously I think probably fairly, if the degree of similarity is particularly great, then that establishes a greater burden on the defence, to the defendant, to an action, to an allegation of copying, to discharge. And of course, as I've already said, the importance now is greater of maintaining coherent evidence of the design process, if there is any possibility that the design might be copied. The decision itself provides, or at least provides a summary of what the law in relation to copying is. It's quite useful in that respect, but I've summarised the position as it is now. This particular decision didn't look at the further question of whether or not there is the matter that the design was copied substantially. That is something that wasn't an issue here, because of course the judge refused it on the first ground, so the judge didn't consider that, but that's of course the other issue that has to be proven at the second stage of section 16. As to whether or not a substantial or whole part of the design has been copied or not. Even if you show that there has been copying, if it's only slight copying or if it's only partial copying, then it may still not fall foul of section 16. So really that's what I have to say about this particular decision, which I think is quite a significant move forward in terms of what the law is. I think there's already a question.
Do we know whether, when Kaldor submitted the design to Leanne, has it been used on any other products, or has it been new design?
I think it was a new design, yes.
If it was a new design, could they have improved their position by disclosing it under confidentiality agreement?
Probably, yes. I mean, those are matters that are, I think, important now, following this decision, yes.
I was interested because I didn't actually think that they were actually similar designs.
Well, yes, that's
we keep to try and fight that. That's right. But it was interesting how you were focusing on copyright. Obviously, that was the decision. But I would have thought that would have been unregistered design right, presuming that they didn't have a registered design.
Yeah.
And of course, so obviously, because it would be industrially produced, section 51, 52 of the Act was kicked in, and this would have actually been an unregistered design rights issue, which I know is tantamount to copyright. So the court and Hakon dealt with copyright.
Yeah.
So was it line drawings, or was it actually the designs themselves used on garments?
I think it was the
Was it possibly
The
the
design
design drawings
possibly,
of
yes,
that? So
yes,
it was
because
copyright.
they looked at that, yes.
Yeah,
yes.
because I thought it was, because obviously they probably would have been in a situation. I had a clothing pattern on my desk not too long ago, and it was a case of we actually were able to get a registered community design for that within a priority period. That did help us out considerably because, again, like with trademarks, if you have a registered design, that's mine. I don't have to prove copying. I just have to show that it's similar. They would have failed on that because I don't think they're similar. But I thought it was interesting how you focus on copyright, not unregistered design.
That's right, yes.
Are not Kaldor actually designers or are they just manufacturers of fabric?
I think they're designers. I'm not sure what the position is on manufacturing.
There's an awful lot of sour grapes on the basis they probably just didn't get the order from the end product.
Yes, that's probably the issue.
There's an underlying thing here, which is that the designers of these fabrics tend to actually end up selling the designs outright to manufacturers, because manufacturers won't pay royalties on them.
Yes, I'm probably
A regular grapes.
Reflect more on the concept of sliding scale. I'm from the US, so I have no idea about this concept.
Yeah, so those are words that I sort of used to, that was sort of my interpretation of that. But what I was referring to, I think, when I said that, was that the judge effectively established a sort of range within which an inference can be drawn. So if you have two designs that, as the gentleman pointed out, may or may not, depending on interpretation, be objectively similar, if they are a bit similar, for example, so if they're, somewhat similar, then ultimately it seems to be the case that following this judgment, the burden on the claimant is greater, whereas the burden on the defendant is lesser. Because if the evidence of copying is on an objective basis not very strong, then of course that shifts the position between the claimant and the defendant. But there may be situations where two designs are objectively very similar, more similar than these ones. So, for example, I don't know, as pointed out, the Joseph bag with just slightly differing lines, in terms of the actual measurements of the lines or something like that, where quite clearly the designs are very similar, for example, then of course the burden on the defendant will be greater, and ultimately in a case like this it will turn on the evidence that's given. But as I said, the burden will be greater on the defendant in those cases to demonstrate its own design process and how it reached that particular design. So that's sort of what I mean. I try to find a way in which to summarise that, really, but that's my summary. It may not be a good one.
Any other questions? Okay, well, thank you very much, Alexander.
Cheers, thank you.